to page 34 of Annexure 1. Page 34. Annexure 1. As you will see, the petitioner has been, the petrol and diesel, which are outside the purview of GST tax, GST Act, those have been taxed. I am just placing that 5.5. Para 5.5.
How can it be?
Again, on perusal of different supply, along with document evidence.
Why you did not produce the evidence before the authority?
No, I have given my
This is the quantum or the amount which
Yes, I have
which
given.
concerns the sale of the diesel and
Yes,
the
yes.
petrol.
And
And
see,
you have multiple sub business.
Yes,
You have multiple business.
quite right.
Some of them are tax and some of them are outside the purview of the VAT, I mean the
Correct.
GST.
Correct.
But you'll have to show to the authority
But-
that these are the amounts which are outside the
I
purview.
have seen, I have shown.
Where you have shown.
Yes, now you will see, I will read that paragraph again, which he has admitted. Again on perusal of defense reply, along with the documentary evidence, I find that the taxpayer has taxable supply sales amounting to rupees 2,86,69,606 related to sale of petrol and diesel. Then, my lords, another thing, 13,20,917, which is exempted by the government notification, and I have given in my reply, that has also not been.
Yes, what do you say? How can it be? Can there be a tax on the with the sale, the diesel and the petrol, this GST?
Yes,
It does
Lakshmi.
not come under the purview of the GST.
Yes, Lakshmi, my page number 36, para number 5.9.
Yes,
It is further the taxpayer calculated the 39 of 6. That is
on the same word, you have to say, if there is a taxable the amount, then you will have to say whether he has paid, he has not paid. But you can't club it, that amount which he sold the petrol and the diesel. You have to segregate it.
Lakshmi, they have given the bifurcation. The major evidence is the VAT return. They have not submitted the VAT return.
So VAT return for that, suppose if a item or a sale does not attract any GST. Is he liable to submit the return?
That's why I have to take
It
extra.
does not. You have to segregate it. The amount which attracts the GST, definitely if he has not submitted the return or something, you can impose the penalty, you can impose whatever you want on that amount. But the amount which does not attract them. How can it be?
So in this matter, the original order was passed in the month of January. And the read petition is filed on month of July. And the appeal period has been
But
given the
still-
appeal.
But the amount has to be segregated. You cannot club it to it. Yes, there is in the reply he has been.
Yes, you may be pleased to turn to page 53 of my reply, which is annexer 3. I have given the bifurcation. Page 53 of my reply, that annexer. Sale of petrol that is pre-GST period and post-GST period. Also may be pleased to see that.
What is that this bifurcation,
Yes,
he has seen this bifurcation,
yes.
but he says that documentary evidence is not. true.
Document evidence I have
That
given.
that is at page 34.
Yes, 34, he admits. But
Yes.
still then he,
But he
No,
says that there is no documentary evidence
Evidence
that it
by
comes within the purview of the
I
act.
have
and that's
produced
why
by
he
the,
has
he himself
taken the
has
entire
verified.
amount as a taxable one.
Well, it's, he has seen these documents.
Where is the document? You tell me when you give a reply. that
59
you
minutes, Rasim see.
Show us that
Yes.
you submitted the documents.
Yes, yes. Rasim see, page 59. Last statement of accounts of Indian Oil Corporation. Then 3B return, that is the sale return enclosures to my reply given to the so-called notice. Vehicle registration certificate, the income tax return. All these things have been submitted manually. And those returns have again been annexed in this itself.
I think with UCL, the transactions are not only relatable to petrol and diesel.
There may be
I
some
think
other items.
because item number 7, enclosure, serial number 7, it seems
7.
some higher charges you
And
have paid.
yes,
So
higher
with-
charges.
With IOCL, you have different business or transactions. Not only petrol and diesel, purchase and sale of purchase and diesel, you are not confined to that. Some other business with IOCL you have.
No, only
That is what it
No, no, lubricants are there, are they not
Yes.
attracting the GST? If you buy a lubricant,
some equipments or vehicle.
so when you have not given a bifurcation, I have seen page 61 and all, everything, it is not there.
60 matters.
16, you are referring 59, we have seen 6 documents.
Yeah.
Then we have
Yes.
gone to a page 60, 61.
Yes.
61 is a very composite one. You have not showed the bifurcation. They wanted, you have to bifurcate it.
Matters may see, I have given the bifurcation at page 53 matters, which exactly fits into his order. Page 53 matters. Page 53 of my reply. Again, I am placing matters. Sale of petrol and diesel VAT regime. It is 47 lakhs 33,263. Wash contract VAT regime 17 lakhs 76,000. Subtotal it comes to 65 lakhs. Then when sale of petrol after this GST comes 2 crore 21 lakhs. And if your lordship will add it up, it will come to 2 crore 86 lakhs. Now, supposing my lords, even in the worst case, that higher charges 13 lakhs, which I said that it is covered by the notification giving the exemption. Even if that is also said to be correct, but still then I am yet to avail the benefit of sale of diesel and petrol, which is not the civil goods matters under the GST Act. Unless the goods are there in the schedule, how can those goods will be subjected to tax? There must be a subject.
Sir, who is going to give owner's slice of whom?
I am
The authority or you?
I am the
Will you
authority.
not,
I am the person.
will you not produce the convincing materials signifying, because he has written that there is no documentary evidence which is filed, which would invite this kind of a decision.
Balance, I have given the return showing the sale of my
Sir,
petrol and diesel.
I have seen the return is very
Yes,
clumsy,
yes,
sir,
yes.
page 61.
It starts from.
Page 61 is so
No.
clumsy,
Sorry, my lords.
it's so clumsy that nobody can decipher anything therefrom.
No, it starts from lordship will kindly see. It is from page 63 onwards. 63. Will your lordship be pleased to turn to page 63? Annexure 5 series?
No, that is a GST form which you have.
No, these are the sales returns relating to sales of petrol and diesel statement balance. Lordship, may kindly see that?
No, that I have seen.
63 starts from 63, then 60.
No, up to 68 I have gone. I have
Yes.
seen that.
Yes.
Even at 69 also there is a.
Original order was
You'll have to pass the very big hurdle. We are grappling with. They have taken, one of the council appearing for the GST, they have taken a particular plea. That if an appeal period has expired and the writ petition has come, the writ petition is not come. I have invited the members of the bar to address.
Yes.
This is a Glaxo matter where the apex court has said no maintainable. The rate is not maintainable. If it is not maintainable, then it's what to do. Tell us.
I have given the medical certificate.
Sir, it can't be,
Balance.
cannot be. That's a, if you look
Yeah, I
at
have
the
not,
Glaxo matter,
Balance.
the apex court, I think in paragraph 35 or 36, have
Paragraph 19 years.
very cut,
Paragraph 19 years.
90, very categorical.
Balance.
It says that no writ petition should be entertained or maintained if the period of limitation for filing an appeal has expired.
Balance.
So I invited all the members of the bar to assist me and assist us.
Definitely.
Because if we have to follow, then this has to be thrown out.
Balance.
And if it has to be thrown out, then neither you are entitled to any equity, nor you are entitled to any interim order
May
in a non-maintainable proceeding.
May I say, my lords, you have fixed a date as your.
I have fixed on the request of the.
10th November.
10th November, I'll be there. Let this matter.
Please give him the judgment of the Glaxo.
Your Lordship. Your Lordship. In court.
Please give it.
I'll give
You are appearing in the matter.
Your Lordship.
You are also appearing. You are not appearing.
Mr. Vishwajit Das.
Vishwajit Das, please. And also Mr. Kora, senior counsel, some of the matters are there.
He's there, but lead case is.
NHI.
uh,
NHI.
Vishwajit Das.
Yeah.
Vishwajit Das.
Please come on, take.
Yes, please.
On 10th.
Your Lordship.
What is decision of the instant petition? Is to
Application of revision petition by the Commission of Income Tax Exemption.
Yeah, but this. Have you filed counter?
Yes.
You have filed counter?
No.
You will not file?
Will file. I have not received.
It is that case, similar matter with the 12A.
It is in clear violation of subsection,
We have.
second provision of subsection 4, section 12.
2025.
Section.
Yeah,
Second provision of subsection 2 of section 12. As quoted.
that proviso says that once it is granted, it
Right.
applies
Ah,
to
okay,
earlier.
to the-
period.
Also. Preceding financial years.
Well, this, you have directed them to file response.
why you are not giving a response? Now I recollect that this point that arose.
Well.
Whether it will have a retrospective effect.
Yes, ma'am.
So.
On the opposite party, just.
Why you are not filing? Response? Despite the direction passed on 16th and 20th.
Item number 4. Item number 4.
Your Lordship, in
The
this
order
day,
date will be different. Yes.
Your Lordship, item number 4.
Item 4.
Your Lordship is directed to take instruction, Your Lordship. Your Lordship, I have not received the instruction, but however, Your Lordship, there is on the last occasion also. I
Not
have-
directed to take instruction.
Your Lordship, I have myself said that to take instruction, Your Lordship, on the by order dated 24th September 2025. Your Lordship is directed. Your Lordship, prima facie, there, it is found that there is.
Have you
some
taken instruction?
Instruction I have not received, Your Lordship. Due to transfer posting of the officers, I have not received. But prima facie, it can be remanded to the assessing officer for face assessment because there are some inadvertent mistake in the order, nature of the. If Your Lordship, once I'll.
We were.
Your Lordship, the DRC 07, Your Lordship, let me, the DRC page 29, Your Lordship may kindly turn to. Page 29, the DRC, sorry, page 29, the DRC 07 has been uploaded. This is for the period 2021. This is the assessment for the period 2020 to 2021. Your Lordship, the annexure at page 33. Your Lordship, inadvertently 3 periods have been mentioned. Your Lordship, initially in the first paragraph, it is April 20 to 21. This has been rightly done so at page 33. And subsequently in the first paragraph, it is 1920, and the second paragraph, it is 2021, right? And in the calculation C, the inadvertent mistake, it is 1819. What happened at the same time? 3 periods assessment has been done.
He
1819.
got jumbled up with
Your Lordship, 1819, 1920, 2021.
So 61 application mistakes have been continued. If it is a mistake, then it has been continued. So on
So, Your
section
Lordship, what
61,
is-
there should cause an order everywhere, Your Lordship.
Then don't be complete.
Yes.
This is.
And-
Apparently, Your Lordship, copy the state, Your Lordship,
Your Lordship, I'll
I
like-
consider it.
In that we have.
Your Lordship, on the last occasion, myself, I have considered that. Your Lordship.
Observe this.
Your Lordship, in the last but one paragraph, paragraph 5, Your Lordship has already recognized that.
Yes, Imam.
Yes.
Item number 5.
Your Lordship, me.
Because it's not.
Because.
Your Lordship,
They already.
Your Lordship, what my respectful submission, Your Lordship may kindly mention that, because if we issue a press notice, then limitation, question of limitation will arise, Your Lordship. So for that reason, the notice may be there.
Back to that page.
Your Lordship. Your Lordship.
It's not
Your
no-
Lordship.
Proceeding remain pending, sir.
Your Lordship, that can be done.
We are only setting aside the order,
Mine.
not the notice.
Your Lordship, grateful.
Are you challenging the notice?
Yes, Your Lordship. Even in the notice, the
that-
same problem persists, Your
Yeah,
Lordship.
that is the notice.
But Your Lordship, the same problem persists.
Take up plea before the authorities, because he has proceeded, we will say whatever the point of demo you have taken, he will decide that.
Your Lordship, what will be rectified?
Have already participated in the proceeding.
That participation has not been recorded, Your Lordship.
Oh, that is now the participation would be full fledged.
Now everything will be recorded.
That's why I said whether to record a date for their appearance. Anyway,
Your
we'll
Lordship,
proceed with
Yeah.
the intimation.
Your Lordship.
Item number 5.
Your Lordship, item number 5 also, Your Lordship was directed to take instruction. Your Lordship, I have received some instruction not to my satisfaction. Your Lordship, I have called for further instruction, and I may be permitted to file counter, Your Lordship.
By 3 weeks, 1 week, regimental, 4 weeks.
Item number 6.
Lordship, but otherwise this impugned order, I'm appearing for the petitioner.
What are the criteria? Next.
Item number 6.
6 and 7. Instruction circular cancellation.
Have you checked up? Please show it to him.
Sit back to this.
Next.
Item number 8, Your Lordship.
Item number
Item number 8, Your Lordship.
Yes.
Cancellation matter.
6 and 7.
No, he's appearing in 6.
7, 6 and
7, he's appearing in both. Okay.
Item number 8.
Item number 8, Your Lordship, is registration cancellation matter. Your Lordship, the order has been.
Yes.
Item number 9.
9, Your Lordship, the matter under section 107 of the CGST Act, Your Lordship, regarding non-constitutional criminal, Your Lordship, it passed the similar order.
Now it has been done. I think we have subsequently taken note of that particular notification.
17 September.
Yes. I know, I've seen.
Item number
Yes.
You are allowing them to file second appeal.
Your lordship,
You have given some time frame. Circular or
So let them file.
that we have observed.
mine.
Whether you are doing it or not, you should.
If they come and file it and they say that I have filed, we will revert the matter there to the.
So you will not henceforth keep it pending.
Mine.
Then
Yes.
say that the number we have got.
Actually, what I have heard, there is some technical glitches. What I have heard, I have not.
System has to be. Yes.
Item number 10.
Item number 10, appearing on behalf of the petitioner, your lordship, this is that service tax 73(4)(b) matter. Your lordship has already sanitized those matters, your lordship. In this
Supreme
case,
Court is.
mine. In this case, that paragraph 4 may kindly be modified. Your lordship, what happened? This is for the first time, and already attachment notices have been issued. Your lordship, in those cases, earlier interim order has been passed, which was directed to be continued. I have modified your lordship, subject to your lordship's acceptance. The last page, paragraph 4, your lordship.
No coercive action.
Get full, your lordship.
Yes. Next.
Item 11.
Matter relates to cancellation by execution.
Next.
Item 12.
Item 12, your lordship, is regarding 73(4) service tax matter, your lordship.
That is pending before the Supreme Court. So
Yes,
I-
yes.
when did I- Yes.
Obliged, lordship.
Item number 13.
And appears dismiss.
Item number 14.
14 minute please, Banka. Allowed in the review application, very short points to be decided in your review petition matter. My lord, child 2 and para 3 and 4. Para 3 I have stated that it is respectable submitted.
Which order you are seeking to review? Which order you are seeking to review?
My lord,
Order dated, please tell me. Date of the order?
26/10/2022.
Huh?
19. 26/10/2022.
Yes, annexure 2.
Annexure 2, WA number
Yes.
19/2008. That case, my lord.
Just 1 minute, sir. I have not read it. Give me 30 seconds time to read it.
How that? Okay.
Yes, sir.
yes. My humble submission, I have stated in my para 3 and 4, my lord, that it is respectfully submitted that by passing the order dated 15/1/18 in
You are not
WPC
seeking-
number.
You are not seeking any
My
interim
lord,
order. You are seeking a review.
Order as well as appellate court order.
Acha.
My lord,
15(1) is a single bench order.
18 is the honorable change the
Correct.
in WPC number 19546 of 2016.
Yes.
The Honorable High Court did not take into consideration the following facts despite the same being available before this Honorable Court. My lord, 2 affidavits I have been filed
Before the single bench.
before the single bench as well as appellate bench also. Affidavit dated at 26/4/2017 of the Executive Engineer LI Division Jajpur Road, OLIC, stating in para 3 that Sri Jayaram Behra, petitioner number 1 minor, has performed his duty under the opposite party number 3 in the said division till 31/5/2009, also annexing therewith the letter dated 19/4/2017 addressed to MD OLIC. After 31/5/2009, the opposite party number one has not done any work. In the honorable single judge passed the order, the annual salary shall be paid after 31/5/2009 till date. Till date, my lord. Then, my lord, second affidavit dated 10/7/2017 of the Executive Engineer LI Division Bhubaneswar OLIC, stating that Gaurav Chandra Praharaj, that is opposite party number 2, has performed his duty under the opposite party number 4 in the said division till April 2009. After that, they have not worked in the lift irrigation corporation. My lord, my humble submission, if these two affidavits have been taken into consideration, then this order ought not to be postponed.
So what is the error? What is the error in this order that show us that it is contrary to that finding?
In the writ appeal, my lord, appellate court has also not taken into consideration, not going to the merit of the matter. Only paragraph 5.
Sir, can I, yes, when this counter affidavit was affirmed, sir. When the counter affidavit was affirmed, sorry. When, what is the date of affirmation of the counter affidavit before the single bench?
Yes.
That is 15/1/2017.
17. If this was a fact of 2009,
Yes.
sir, in your paragraph on affidavit, you have said that you have not retrenched him as of now. That means that you have allowed him to continue.
By virtue of the increments.
If there is a conflict, then what? Which the court should take into account. Your own counter affidavit was relied upon. So what is the error? What is the error?
And this is the
So we will say that it's a prevaricating of the stand which it does not.
after that, in 2019, another writ application have been filed. In that writ application,
Have you disclosed that before the appellate court? Sir, you are in review. That's why I am asking all these questions. We will not enter into the merits, sir. We will simply restrict whether what is the error apparent on the face of the record and what should be done. Nothing more than that. We will not enter into the merit. So whether those facts were there or not, you have to satisfy that these were there.
these two affidavits are there before the Honorable Single Judge as well as the appellate court.
True, but your counter affidavit was taken into consideration, which is the primary one.
Para five.
Can you distract once you have stated all these on oath? These are all on oath. Can you recite from there?
No.
So, if the court has proceeded on that basis, then what is the wrong on the part of the court? Though I was not a party to that.
Yes.
I'm supporting my brother who was a party to that order.
So my humility matters. The fact matters, the fact remains. Here in this case, Honorable Supreme Court remanded the matters to their requirements, allowed them to file a review petition. What they did is.
Sir, we are aware.
No, then my Honorable Justice Raman matters considered of this sort of put the same question.
My brother has to say what is the error. Yes. Yesterday, I dictated 2 judgments on the scope of a review.
Yes.
It took around 2 hours, sir. Consumed.
Very limited, sir. We can't go and reopen the entire issues.
To pre-verifying this.
So by way of an affidavit, you take a contrary stand than what you have already said in counter affidavit.
Yes, ma'am, that.
Very difficult to.
I think my brother quoted that portion of the counter affidavit filed by you.
Yes,
What you stated has been quoted there
in the counter affidavit also. I-
in toto. It is not that they are in toto. Brother, is your baby you have to. Brother will pass you.
Yes.
Right. Yes. Item number 15.
You know what, limited prevention case man. Herein what has happened, one notice emanating tender was floated by the chief engineer of Bolter Bathing Miners, wherein they have called for application regard to supply of manpower for skilled, semi-skilled and labor classes of people. And accordingly, my petitioner has participated and declared a successful bidder manner. And chief engineer is directed to the superintendent of engineer to execute the agreement manner. But till date, he is not executing, even though it has been
Adjust as the lowest bidder.
no highest bidder, man.
Highest bidder.
Yes, successful bidder. ma'am.
Successful bidder.
Yes, ma'am. And chief engineer,
Madam,
Instructions.
there's madam. You were served with a copy of the writ petition when
Totally, but your lordship comes for the first time, notice, 1 week.
that this particular concept I wanted to eradicate from this. That since the matter is, the matter is listed for the first time after 4 months of service, you will ask if the first time the matter is listed, let me take an instruction. When you have been served with the copy, you know that what case he has made out. You should immediately contact the concerned officer, seek an instruction that what is his instruction to expedite the matter. It could have been disposed of on the day one, unnecessarily dragging on the matter.
Lordship's office is organizing. First, we have organized the criminal part, your lordship, the criminal
No, this
cases,
is
we
not
get the
organizing.
instruction.
You have to, when you
Now
are
we are-
entrusted with the blame,
Yes, your lordship,
You should-
we are trying to do it with the writ applications also, your lordship.
this is not expected.
1
1
week,
week,
let it come next week.
1 week.
Item number 16.
Next.
16.
In your lordship, you receive the instructions, you need to file an affidavit, your lordship. Also explaining the facts and circumstances, your lordship, with the case being an SLP pending in the Supreme Court, your lordship.
but that SLP has nothing to do with the refund of this EMD.
The refund of EMD.
EMD, because my bid validity is over since it.
Which matter is pending before us?
The Supreme Court, your lordship, relating to this tender, your lordship. This tender.
This tender, the tender must have been,
It was cancelled and a retender was made. But
Correct.
this honorable court
is made
cancelled.
the order of cancellation and retendering.
Yes, your lordship, but this honorable court squashed that order, your lordship. And that is what went on an
So he does
SLP.
not want to continue. You please give back. He will not be considered to have been, to have participated. That's his conscious decision.
Yes, your lordship, but that is what my instruction
Whatever.
is. I will,
Then he'll have to return it,
1 week.
treating that he has not participated as a special case.
I
That is
will,
what
I used to raise to bidder. So in either way, the SLP comes out, my lord, it will not have any impact because what has happened, my lord.
I will look into it.
Suppose if the L1 refused, then they will offer you. So you have to take a conscious decision that you will withdraw your offer.
If in the letter, my lord, in writing.
You want to withdraw.
Yes.
It will not be considered as that.
I-
Why don't you get
Yes, your lordship.
what?
That letter is.
1 week time, your lordship, I will convey to them if there is no other, that the instruction says the same thing, your lordship, that lordship may pass any order because my instruction says that since he's the L2 bidder, if the L1 is,
What is the fact? The fact is that the tender was floated participated, you are the L2.
Yes, my lord.
Then thereafter somebody challenges that particular tender.
My lord,
They,
somebody,
sorry, they cancelled the tender.
no, my lord, may I just,
No, no, we have to record the fact, that's why we are
I'm
asking.
just placing that. I stood as L2. At that point of time, the previous tender, which was cancelled and this tender was floated, the successful bidder in that tender has filed a writ application challenging that cancellation as well as the floating of this new tender. That this honorable court has already quashed that this cancellation is quashed and consequentially this tender call notice is also quashed.
Correct.
So challenging that, the L1 bidder in the present tender call notice has filed an SLP. So in either case, if my lord,
Any interim order is passed there?
no, my lord.
Nothing.
I have annexed the SLP order, last order of the SLP.
Admittedly, the petitioner appears to be a confusion in your mind. Your facial expression suggests that you are still in a confused state of affairs. No.
I'm obliged,
Item 17.
Regarding PL man, increasement of common land man.
What?
Increasement of common land man, OP number 5.
We have already directed in other matters. And now, yesterday, I think, the advocate, Mr. Tripathi says, the government has already taken a conscious decision of no tolerance on encroachment. He just submitted that particular decision of the government.
Yes.
You will have to initiate a proceeding. You can't sit tight over the matter. The government land is being encroached by the squatters, and you will just keep on.
I think that has gone to all the collectors.
Yes,
Yes, sir.
That is submitted to all the.
They have already.
Already started.
And another one is
We will instruct.
This is the recent decision which the government has taken. Showing the no tolerance on encroachment. Initiate a proceeding.
What is the matter?
It is Cutter Collector, Your Lordship, and Niyazi Collector.
Yesterday.
So I will take instructions, Your Lordship, 1 week time.
What instruction? Is your counterpart is here?
It was yesterday, item 5.
I don't find.
Yes, sir.
That the decision of the government, the notification and the office memorandum, everything was reproduced. Don't you have extra copy? Same order would be possible.
Right.
Here you have not initiated any proceeding. We will simply say that if not already initiated, shall initiate immediately the proceeding. Already initiated, then continue.
Yeah, already in 2024, first year of the address to all collectors.
Yes.
We already issued.
This was the another, we have not recorded. We will record that decision. Simple. This is.
Yes. Yes.
Yes, call the things.
Item number 18.
My lord, seeking permission to appear online, my lord.
Yes.
This issue relates to, my lord, the use of fly ash in the construction.
Of the water body. Instruction of the agricultural livelihood. Disposal of the fly ash.
My lord.
Why not you appear before the green traffic?
My lord, this is something, my lord, environment plus
Environmental-
issue, my lord, not.
Environmental issue, then why directly to the Red Court?
My lords have now, my lord, changed the law a little bit, my lord. So the issue is not only for Schedule 1, my lord.
They are equipped, they are specialized.
My lord,
CORAM is there.
I bought down, my lord, but this not relative to entirely for Schedule 1 matter, my lord. This is something, my lord, breach of contract, breach of directions, my lord, irresponsible way, my lord. I might just see the show lordship the directions, my lord, as to how this was to be conducted and how the excavation was done. So, my lord, the NGT would be little, my lord, slow in interfering the issues which are beyond Schedule 1.
Prayer A, if you come to your page 21, the prayer is removal of the accumulated fly ash from the agricultural land, water bodies. Second one is comprehensive timeline assessment to evaluate the environmental damage. Third prayer is compensation to the farmers. All these things can be done.
My lord, if
Talk about the Pollution Control Board to submit the detailed environmental impact.
my lord, in
Nothing,
fact,
the contractual obligation, nothing of that kind, sir.
my lord, my submission is this, my lord. In fact, so far NGT is concerned, my lord would see that it is bound by Schedule 1. My lord, Schedule 1 does not have the contract as to how the work was to be executed, my lord. The problem with
Why not? Where is, show us the schedule one? Do us.
my lord, NGT, my lord, there are only 6 laws, my lord. I mean, the wildlife, forest,
I
air,
believe-
water.
I may be wrong, you'll have to just satisfy me on that score.
But then there are judgments, my lord. They say that my lord's power cannot be
You show
curtailed.
us
Lord, that
the judgments are
Bhopal,
definitely, but
my lord, Bhopal Pidit Mahila was, my lord, diluted by the Supreme Court twice. In 2012 and 2024. So that is the reason, my lord, which I have come before your lordship. And my lord, I'll show one document as to why the problem has crept in, my lord. Annexure 9.
no, I understand that was a case of a different nature, whether this can be done in this way.
I'll go down.
National Green Tribunal.
So, my lord, the Green Tribunal will be, my lord, my lord, as per my little knowledge, my lord, Green Tribunal will be, it will be difficult for Green Tribunal to, my lord, grant relief. The moment, my lord, it travels beyond environmental, my lord,
to satisfy on this, the preliminary point. You have to.
my lord, then whenever, my lord, direct me, I will also get prepared on that. Because Green Tribunal has very limited, my lord. It is a tribunal who cannot, my lord, supersede my lord's power, my lord. That difficulty is there.
What are you talking about? The administrative tribunals even have been given a power to declare any of the provisions as ultra
My
vires.
lord, only respect of 6 laws. Only respect of 6 laws. Schedule 1, that's all.
Whatever.
If I satisfy your
say that
lordship.
the tribunal do not have the power. Take care. And
Yes,
Chandrakumar, you are aware.
My lord, then I will take, my lord's 2-3 days time, my lord. I think I will not be in
Chandrakumar's case.
little bit inadequate, my lord, to convince your lordship.
This 1 week.
Ma'am.
The lordship of appearing on behalf of OP number 2 copy has not been served, 1 copy.
Please serve the copy.
I'll do that. I'm so sorry, my lord. I'll do that.
Course of this week. Great.
But Lordship is right that the tribunal has a power, ample power to
No, I am
interpret.
satisfying, my friend. I am satisfied to lordship. Don't worry about that.
Fine,
That is the
madam.
first hurdle I have to cross through.
Yes.
I lost it.
This course of this week.
Item 19.
What?
That's popular in April some cases.
We have got it.
What is this?
That EAL.
Your Lordship, your apology filed submitted a affidavit to your Lordship on behalf of the Excise Commission, your Lordship. You've not been able to e-file it, giving the affidavit. That order has been rescinded, your Lordship. It was just an oversight. Lordship is saying that she has put down all the contentions of the petitioner and also the superintendent of excise, your Lordship. It was just an oversight of the last paragraph, your Lordship. It will not be repeated. She begs unconditional apology.
That commissioner.
And passing this order prior to that. Is it?
My lord,
Is it?
he has passed a elaborate rigid order, my lord, at annexure 17.
So this is not a duplication of the.
No, duplication.
Not the application.
No reason has been assigned. Only submissions has been noted and conclusion has been given within 3 lines.
No. Region has been given, my lord, at page 102, paragraph 9 and 10. And
And
findings
it's a
also.
submission of the superintendent. That is superintendent excise submission.
Yes, and findings.
101 you
Where is the finding?
Finding is.
These are the
in
submissions recorded 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Yes, findings is in the bottom.
where is the reason?
From the above facts and circumstances and available records, it is found that he has violated. How he has violated? Will he not give a reasons?
This, depending this sort of.
No,
Sir,
reminding-
reason may not be there, but
I am reminding you of the Supreme Court judgment, innumerable judgment, 2 immediately I can. 1993, volume 3 SSC, Simkumar Chadda. And
Mohinder Singh
is
is
1994, volume 4 SSC.
Mohinder Singh Gill also there.
Mohinder Singh Gill is also one of that,
Yes.
19, old one, 78. 78 1.
Lordship's
Oh.
recent judgment is there. The Lordship's recent.
but no, elaborate reasons need not be, but
Yes,
some reason.
Nothing.
Rationality.
I have
Come to
taken,
this conclusion.
I have taken the 7, 8 grounds.
The
Lord.
entire facts.
The closure has been met without exercising 26.
Preceding some, the
noting of the submission, Lord, your Lordship may see 98, 99. The entire case has been discussed.
I'm telling you, by my experience, sir, when I was at the bar.
But my representation for extension of queries has been rejected by the authority on the ground that under Rule 8(4) of the Orissa Mineral Concession Rules, my lord, there is no such provision for extension of the queries. On that, my lord, my sole ground is management sole ground to challenge the decision.
Sure.
Yes.
It permits the extension.
Yes. Now, Lordship, first of all, Lordship, kindly appreciate that this delegated legislation has come from Section 15 of the MMD Act. And Section 15, it says that the power of state governments to make rules in respect of minor minerals. Hello.
Yes.
Lotsmith and subsection 1, the state government may by notification in the official gazette make rules for regulating the grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals and for purposes connected them. 1A, in particular, and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters. Your Lordship, kindly see the Rule D, sub-rule D. The terms on which and the conditions subject to which and the authority by which quarry leases, mining leases, or other mineral concessions may be granted or renewed. Now, under the Act, they have empowered the state government to frame rule for renewal of such lease, and that is permissible under the rule. Now, your Lordship, then go to the rules, the Odisha Minor Mineral Concession Rules. Rule 8, sub-rule 4.
2016 rule.
Lordship. Rule 8, sub-rule 4. Says that maximum period for which a quarry lease may be granted shall not exceed 10 years and shall be subject to such terms and conditions as may be specified by the competent authority, provided that the minimum period for which any such lease may be granted shall be 5 years. Now, admittedly, there is no such phrase for it to be extended up to 10 years. Such kind of phrase has not been used in this particular rule. But your Lordship can take reference, can look to Rule 36.
Or power of relaxation.
No, Rule 36 says this is a quarry lease, and Rule 36 comes under Chapter Chapter 4. The Chapter 4 is Chapter 4 deals with grant of quarry leases under which this quarry lease has been executed, and Chapter Chapter 5 deals with grant of quarry permits. Now, Lordship, for a moment, Lordship, kindly see the definition of quarry lease and quarry permit.
In the rules itself?
Yes, ma'am. Quarry lease is at Rule 2U. Quarry lease defines quarry lease means a lease granted on tenure basis for extraction, collection, and or removal of minor minerals other than specified minor minerals over a compact area. It's a tenure basis lease. And quarry permit, it is there at W. Means a permit granted for extraction, collection, and or removal of any specified quantity of minor minerals other than specified minor minerals under Chapter 5 of these rules. Therefore, first of all, a quarry lease is to be executed with a proponent, and then after quarry permit is to be issued to that particular lessee. In this context, we also kindly see Rule 36. Rule 36 of Odisha Minor Concession Rules. It says it speaks about duration of quarry permit, and it says the period of quarry permit shall be as per the project period and shall be usually for 3 months, which can be extended up to 1 year or.
Oh,
I'm sorry.
yes, let him put something, leave something for us.
I'm sorry.
I mean, I will put a query on that.
I'm sorry.
Query for a query permit.
The period of quarry permit shall be as per the project period and shall.
What is your condition?
Well, the last sentence. Last sentence of this
says that it applies to this, your permit.
it says that in case of extension of the project period.
Does this provision apply? I'm talking.
Yes, madam.
Yes, come to the query permit definition.
Hello. Means a permit granted for extraction, collection, and or removal of any specified quantity of minor minerals.
Then read slowly. Other than
Specified minor minerals.
under
Lord,
Chapter-
chapter 5 of these rules.
you are talking section 36 comes under chapter 5.
Yes, Lord.
So if it does not come under the definition of the query permit, then
Well,
what
other
is the
than
meaning of the word other than the minor minerals comes under chapter 5.
well, it is applicable to all. It is applicable for extraction, collection, and removal of.
Sir, if it has been kept outside the purview, then definition itself excludes
Lord,
that the query permit, so far as chapter 5 concerned, it does not come under the purview of this definition. What more?
Lord,
Can you take advantage?
Lord, here they say that in case the query permit, Lord, the language used is, Lord, that in case the query is extended, the lease is extended. Lord, you also kindly appreciate that the language.
Sir, there are two concepts. One is a lease and another is a
Permit.
permit. Duration may be there, the permission may be restricted for a particular purpose, maybe for some reasons. For ascertainment of the royalty, the ascertainment of the other additional duties, the ascertainment of the other liabilities which the query permit holders is liable to discharge. All these things are there just to ascertain. The duration should not be confused with the permit. There are two concepts. Both relates to an extraction. Both relates to an extraction, collection, and the removal of specified quantity. Release is for the purpose of query. That this
For
is
area.
a demised area
Yes, Lord.
where you are permitted to operate query. Now, how much specified amount is within the permit? You cannot go on and
So
extract
It would also be, Lord, I bow down.
infinity. You know, they have restrictions. Secondly,
Lord,
query permit does not come within the purview of this chapter 5.
Lord, may I just trying to convince you, Lordship, on this, the word used that in case of extension of the project period. Now, in case this
Sir,
government,
I am again provided the query permit must come.
query permit.
I do not find the query permit, it says means a permit granted for inspection. Other than the specified minor minerals under chapter 5 to this one. So whatever has been described in chapter 5,
That is not applicable.
then it will not come under the query permit of the petition. Now you tell me that
Lord,
to provide.
yes. Lord, I was taking recourse to rule 36 and rule 59, Lord. To rule 30.
Yes.
Prospecting license from mining lease or quarry lease obtained in contravention of the act and rules. Now, Lord, may kindly say that any prospecting license from mining lease or quarry lease granted or renewed or acquired in contravention of the provisions of the act or any rules or orders made thereunder shall be void and have no effect.
So,
Therefore, when the rule itself will not postulate, when the act itself postulate and give the power to the state government to frame rules for renewal of the lease, and when this rule 59 also
the
itself,
language of this section which you are talking about, it says any or the whole of the followings. So this language is that it can be restricted to some of the items which are there. It does not mean that he has to frame rule for all. The government may not.
the power of omission is still there with the government.
So,
But now since the word renew has been used in rule 59, and in respect of quarry lease also, now the government cannot say that the scope of renew is not available.
what is the purpose of the renewal? Then I was just keeping whether this word renewal and the extension are coextensive or synonyms.
No, these are two different concepts. No? In case of renewal, a fresh lease is executed, whereas in case of extension, it is a prolongation of contract. And the deed, the lease deed remains, my lord, same. My lord, having
It is only the tenure.
tenure is extended. Not so. Now, my lord, the language
It
used
does not talk about the extension.
it not doesn't talk about the extension, but the language used in rule 8.5, rule 8.4, my lord, that it cannot be minimum tenure is 5 years, my lord. The similar
And
phrase,
maximum cap
Yes.
is also given to the 10 years.
yes, my lord. So, my lord, similar, I've just brought one judgment.
You have enjoyed for how many years?
5 years. Almost this is ending in this November. But I have taken the ground that during COVID period, the usual commercial business that could not have happened, and therefore it needs to be renewed or extended as per the decision of the authority. But they have taken recourse to rule 8.4, saying that this is not permissible. That is my this whole ground is that if you lordship will kindly I've just cite one judgment.
Presentation.
COVID. But they have rejected
2 years.
Was there any force majeure clause in your lease? No. If there was no, then what did it?
Lord, I just para 20, you know. Lord, here what has happened, Lord, you will also I'll take back to the facts of the case, Lord. That the question of appointment of director of the enforcement director was in question. Now that the eligibility criteria was suggesting that no person can be remain to be appointed beyond a period of 2 years. Now this person, who has continued after 2 years in service, his continuation and extension was challenged before the Supreme Court. And the Honorable Supreme Court has observed that since there is no such exclusion incorporated in the Act itself, that it cannot be extended beyond 2 years, so a negative inference cannot be drawn. This is what I'll take to
There is no distinction. In this case, it was said that it should be a minimum period of 2 years.
minimum.
There was no outer limit which was put therein. But once the legislature has put the outer limit, can it cross?
Therefore, I'm requesting the
If it says that he shall be appointed for a minimum period of 2 years, and there is no consequences, there is nothing outer cap which is fixed therein, then if he is allowed to continue, then it cannot be said to be against that particular spirit of this section. Once the outer cap limit is given, then beyond it, it cannot. But recent judgment, if I go away from a civil law, Arbitration and Conciliation Act, Section 34, outer limit is given. The Supreme Court, innumerable judgment says you cannot extend Section 5 does not apply. Recently, under the Commercial Courts Act, the time limit for filing the written statement is also given. Outer limit is also given. The Supreme Court has said it's mandatory in nature, cannot be relaxed. Similarly, you have to understand the nature of this provision. If the nature of the provision suggests the outer limit beyond which no power is conferred, then
That is what 35.
Not
My lord has said. It's
Yes. Lots of, so because
So
now,
2 years is given, 2 years.
but in spite,
More than 2 years, it is.
but yeah,
Then,
my
then
pardon.
it can be.
But
So in the rules it is may,
yes,
then may, where is the manual?
I
If it is may, then where is the manual?
but the argument for the Honorable Supreme Court was since the rule doesn't provide extension.
Which-
But I have another
I
question.
think you have misread the judgment.
Lord,
That context, it does not apply in this case.
Lord, may I just want to one that in this case, Lord, the agreement was initially for 5 financial years and which expired on 30th of March 2025. Lord. Now they executed supplementary agreement with me.
Yes. We have corrected our error.
So once
We have extended for
executed
this
supplementary
period
agreement,
7
they cannot
months and we have
You have
given.
extended it.
Yes, we have
extended up to November 2025.
5 years.
Lord, my humble submission,
That was an
as per
error.
rule 8.4, it cannot be beyond 5 years. Once because the
statute itself says
No,
that
beyond 10 years, so they have a.
minimum period is 5 years, my lord. Once they have executed a fresh agreement, it cannot be curtailed beyond 5 days, up to
What?
maximum.
No, sir.
Lord, they have,
No, sir.
Lord, they have,
No.
by their own conduct, my lord, they have
No.
executed an agreement, supplementary agreement, so therefore they cannot say that
No,
there is no scope.
I don't believe that. Your interpretation, no.
Lord, if 8-4, if lordship will see,
Yes.
now it is a fresh agreement. Once they executed a supplementary agreement, it is a fresh agreement, and a fresh agreement cannot be executed
Oh,
lesser than the period of 5 years.
true. Yes. What itself says that not beyond 10 years. So it does not say minimum 5 years you have enjoyed. Beyond 5 years, they can extend up to 10 years. It depends how many, that's a duration is up to them.
Yes, but I was not allowed to complete 5 years. Therefore, they executed supplementary agreement.
There was no force majeure clause.
Lord, but they have, instead of that, they have executed supplementary agreement.
Supplemental agreement is in addition or.
But it's a
or
fresh agreement.
supplementing, not supplanting. You are talking about supplanting an agreement, and you are talking about supplementing an agreement. There are a vast distinction. You are now saying that this is a supplementary agreement, but it is supplanting the agreement. When you talk about a fresh agreement, means that the earlier agreement has gone. It's a new agreement which has come. Supplanting. That means supplanting.
Yes.
But it is really supplementing or complementing.
In the response, my lord, they say new agreement has been executed.
No, we have not said new agreement.
No. The instant petition.
No, that is referred to in another case.
Still some.
Yes.
Item note 22.
Findings. The Odisha Hydro Power Corporation Limited rules. Two of the rules are being challenged. So far as they are ultra vires, the Odisha Electricity Reforms Act. Now, petitioners, my lords, you were all 13 petitioners before your lordship, my lords. 11 of them were junior engineers, initially appointed as junior engineers under the state government, and 2 were under the Odisha, erstwhile Odisha State Electricity Board, state government PSU. Now, they were all appointed between 88 and 92. 88 and 90. 95, my lord, the Odisha Electricity Reforms Act comes in. In the Odisha Electricity Reforms Act, your lordship may kindly come to page 110. 110, my lord. In section 24. Provisions relating to personnel. What you got? Section 24, page 110. The state government may, by a transfer scheme, provide for transfer of the personnel to GRIDCO and OHPC. This was when the Odisha Electricity Reforms Act came, was enacted in 1995. En bloc, civil and electrical engineers were transferred from the state government and the PSUs to the Odisha GRIDCO and the Odisha Hydro Electric Power Corporation. The state government may, by a transfer scheme, provide for transfer of the personnel to GRIDCO and OHPC on the vesting of the properties, rights, and liabilities of the GRIDCO and OHPC under section 23. Then, my lord, upon such transfer, under the transfer scheme, the personnel shall hold office or service under the GRIDCO or OHPC as the case may be, on terms and conditions that will be determined in accordance with the transfer scheme. Provided, this is the, my lords, clause, provided that such terms and conditions on transfer
Will not be less favorable.
months. This was reiterated in the
What detrimental to their
month,
existing.
what they originally had. And they had also given an option for consent. In the meantime, pending that, they were holding their lien with the state. So we exercised our consent and came over to GRIDCO and
Then my lords, annexure 6 series, that is the page 129. Your lordship finds in exercise of the powers conferred by section 55 and section 23 and 24 of the Orissa Electricity Reforms Act, the state government do hereby make the following transfer scheme rules for the purpose of providing and giving effect to the transfer of undertakings, assets, properties, liabilities, proceedings, and personnel of the Orissa State Electricity Board.
That is there.
That is there.
The scheme making power, they make the rule.
Here also, my lords, here also, your lordship may come to page 132. The same protection has been granted. 8A. The transfer of personnel shall be subject to the condition that the terms and conditions of service applicable to them on the effective date shall not in any way be less favorable than those applicable to them immediately before such date, and all benefit thereunder of their respective services rendered.
Yes.
Subject to subclause A, OHPC or GRIDCO, as the case may be, shall frame regulations governing the conditions of service of personnel so transferred under subrules 5 and 6. So under 5 and 7. Under this proviso, the OHPC frames its service conditions. That your lordship comes to page 231. The notification dated 2000, 1st August 2000, page 231. Pursuant to the decisions of the OHPC. Then, my lords, we are hit by the rule
5.4.4.
5.4.4 and the further amendment also in annexure 9, that is the 166 board.
Let us see 5.4.2.
The executives not possessing the prescribed qualification under the OHPC recruitment rules for entry into level 3 service shall not be considered for promotion beyond level E5. Now, here, the restriction comes in as to up to the level E5. Now, this was further watered down in annexure 9, 289, your lordship. This is the board meeting dated 11/3/2022, second paragraph. The 166th board has also decided to consider the career progression of diploma holders, junior managers, up to the post of assistant general manager E6 grade in OHPC. Accordingly, the relevant provision of the rules 5.4.4 of the OHPC rules, service rules, is also modified with immediate effect. Now, our original terms and conditions, my lords, your lordship may find, we were appointed, and before that, I'm sorry, before that.
I understand your case is that the minimum eligibility criteria which have been intended to be fixed for the purpose of making you eligible to promotion. Now, according to you, some of them do not possess those qualifications. And therefore, they have been denied the opportunity of promotion.
Proceed
And
beyond
in virtue of this, when it says that it should not be less favorable to your service condition.
Exactly.
Then in that event, by putting any kind of a restriction into a future avenue of promotion, that is less favorable to you. So it offends the very core value of the parent act.
Parent. That is what you wanted to say. Is the core issue. That is the core issue as otherwise so my learned friend is appearing for OHPC, searching to.
No, we have instructions to. Lordship, we have the instructions to appear in this matter. However, your lordship, I'll next time when I'm.
I must be very kind. I'm stuck by my own job. I have heard other.
But
I mean,
in favor of.
When it says that you cannot vary the service conditions, clearly on transportation from one place to another.
Yes, but
if the statute says that you cannot, then.
Of course, your lordships, I'll come up with a counter on that, but I think in service law, your lordships, what happens is, as far as promotion is concerned, every employer has the right to vary the promotion. The law promotion is this, that you have a right to be considered for promotion if it's available. And that right
understand.
does
I
not
am
create a
conscious-
fitter.
I am conscious that a right to promotional post is not a wasted right.
Yes, your lordship.
Nobody can. But right to be considered for promotion is definitely a right incident to service. And you are denying
That
their
right.
right to be
Right to be
considered,
considered.
whether they will be promoted or not,
Now that's-
it is within your domain, within your wisdom, within your decision. Nobody is going to, but you are denying their right of access.
Threshold.
Whether you will permit a person to hold the podium is within you. But you cannot prevent him from entering into the auditorium and then say that
No, I think.
I prevent you not to enter.
I think the reason why this restriction is there on the ground of qualification.
That is what I'm saying,
Yes.
that when you talk about this, that is that even if it is not, suppose if they were there in their parent organization, are they, whether they were not entitled to promotion, they would have been entitled to promotion. When you wanted to transfer the employees and block and treat them as the employee, unfavorable, at least to them, you can put the conditions. But for them, you should have.
Oh, I think, your lordships, as far as the diploma and the degree engineers are concerned, that kind of a qualification and difference in holding an higher post probably exists even in the government service.
I am not,
Yes.
I am not.
So I'll probably have
I'm
to.
not saying it
Yes,
at
I
all,
will
but-
have to probably examine whether they had that right or not, even in their,
To be considered.
in their parent, yes,
You
that
said
we'll
that
have to
if
see
they have
that
a right,
also.
Yes,
We have to
definitely,
see
if
that.
they had a right, that
Well,
right you
and
cannot
probably-
take.
That
If
I
they did not have a right, they can't
And
claim.
then
If I did not
probably-
have the original right, then
Yes, and probably, I will also
I
have
mean,
to
I
test,
obviously would not have come to your lordship.
and probably I have to also test it with the other Supreme Court judgments,
What?
which
There are
which
two
do say,
judgments.
no, which do say that as far as promotions are
You
concerned,
have a right to put any kind of a conditions for the promotion, no doubt about it. But it should be within the framework of the law. If the law says something else, then you do it. I'm just asking this question. If the law says that you cannot put any conditions which is less favorable to them or deny their right of promotions, then in that event,
yes, but that
right to be considered for
Yes.
promotion.
Yes.
Then
But
in
that has not
event,
been
You
played.
are
We do
going
not know
against
what
the-
right they
against
had.
the statute itself.
No, we do not know what right they had. We do not know whether that to that level they were promoted or not.
When it is drafted and coming from him, he must have tested it, he must have gone through it. Otherwise, he will not come.
Lordship. And I should get a chance to see
This is
that.
the- Are you proceeding for a promotional examination?
Your Lordships, because we were just
Yeah,
told
down to
today, Your Lordships, we were told, I have to
31st.
seek instructions in that manner.
Then proceeding in terms of the act, not the rules, not the embargo and the law.
What?
Your Lordship, that would be,
31st,
that
the
would be,
promotion is,
If that rule is not going to be struck down.
no, it was, it
You
can
are-
be.
you are- The problem is, the situation is that what would happen to those things?
No,
Are they, whether they will be permitted to?
we
participate?
will not be permitted to even consider. We are out of the zone.
Your Lordships,
Madam, why not you permit them to?
Your Lordships,
Then, with all the decision,
Your Lordships, I think that would amount to stay on the rule itself, Your Lordships. And I think the virus matter, at least the counter should be there before Your Lordships.
so madam,
Your
that will
Lordships.
be there, but if apparently it appears from the record that this is the situation, then why not?
Your Lordships, this.
You cannot read, suppose, madam, I'm putting you a particular question. Suppose ultimately at the time of final hearing, it is found that this is absolutely unauthorized. Struck down. Then whatever the action which you have taken on the basis thereof, what would happen?
Your Lordships,
The law says that no, you can't.
yes, and we
So
can.
once the
DPC,
right,
Your
then the equity will come into play. Once the right is created, then in that event, it is very difficult to take away that
Your
particular.
Lordships, review DPCs will happen. They'll have all the benefits, Your Lordships,
A
retrospectively.
person who has already been promoted, can you demote him?
Your Lordship, does happen, Your Lordship, that does happen.
Never. I have a doubt.
No, Your Lordship,
And the strongest of doubt on
no,
that.
Your Lordship, that has happened. It has happened, Your Lordship.
What has been done on the teeth of a particular provision which has not been struck down? Then it will take a prospective effect. Then what would happen to the incident which has already?
Your Lordship, then I would say, as far as the promotion aspect is concerned, if Your Lordship gives me 1 week time, I'll seek instructions and we'll come back, Your Lordship.
Then only one thing we can do, if you proceed on that basis, definitely those process will be subject to the result, but you will not withhold, will not disclose the result.
Your
You
Lordship,
have to keep it, you have to keep it in your seal cover.
Your Lordship, give me just 1 week time. 1 week time.
And he's
But
saying
Your Lordship,
October.
just, no.
October,
Then Your Lordship, just,
tomorrow.
Your Lordship,
Tomorrow we'll have-
these rules were very old, Your Lordships. They were staring at them. They also have come at the last moment, Your Lordships.
They never realized because it does not create any impediment to them because they did not accrue the right to promotion.
Your Lordships,
considered-
Your Lordships, Your Lordships, they knew it at least during the time they were holding that post, that to the next post, they don't have a right. They knew it. I'm just saying, Your Lordships.
Can it tantamount to waiver?
I'm not saying that, but Your Lordships, today when they are seeking, I mean, they should be equally generous to us.
Very interesting line of thoughts.
Your Lordships,
That if somebody sat over and did not challenge that particular provision, then he will be debarred from challenging, even if that provision
no,
is
I'm not saying that. I'm not
Even
saying
if
that.
that provision is unconstitutional.
No, I'm not saying that, Your Lordships. But what I'm only trying
I'm
to
just
say
trying
this.
to understand the law.
I'm only trying to say this, that as Your Lordships are trying to make an interim arrangement, keeping a lot of things under consideration, at least give me a time till tomorrow so that I can take an instruction from OHPC that what exactly is happening and how the scene looks like, Your Lordships. So that, Your Lordships, then at least tomorrow only, Your
The
Lordships.
only thing which you make us that in their parent organizations, that they have a right of promotion, which is practically equivalent to the promotional post. If that being the position.
Your Lordships, just tomorrow. Tomorrow we'll get instructions.
I have a strongest of doubts of that.
Tomorrow, Your
They
Lordships.
come tomorrow, but
Because
the
Your Lordships.
difficulty is that we will not say you may proceed, but at least the result should not be published so that a right is not accrued to any person.
I'm only praying, Your Lordships. I'm only praying. May the same thing be passed tomorrow. That's the only thing I'm praying. If they say that tomorrow the DPC is going to be held. I don't have any information, at least not when we were asked to appear. And if they are saying that they did have that right, I cannot stand in the way of Your Lordship's order. But just I'm asking for a time just till tomorrow.
Even you stand in the way, the court will pass it.
Yes, Your Lordship, it's just a way of. I probably would not put forward any defense. That is exactly what I'm trying to say. Just give me a time till tomorrow.
Sorry.
Just follow the timing. Follow the timing. It will be there in the first matter. Follow the timing.
Tell me, couple of other benches
There is
also.
a special pace to work. We don't know how long it will be.
I'll be waiting.
Item 23.
Yeah, this is a case where there's a letter dated say 2023. Next should take. Base 218. Yes. Why you are challenging this? Well, it's annexure 10, page 219. 213. Also. 213 is my request. True, I've seen, but your prayer is that you are challenging it.
Annexure 10, not 8.
But what is your prayer?
Let's see, annexure 10 series.
Then a prayer.
10 series, dated 10.
10.
Yes.
Annexure.
This comes from page 219. You should understand. 219. This is the
1010.
Yes. This is under 1010. And it is under annexure 10 series.
219, your lordship says. Why don't you give a number?
Annexure 10 is in.
Because a copy of the letter.
No, that covering letter is page 218.
And this is the
That is the 18th October. 18th October containing the decision of.
Yes. Here they have referred to letter dated 1010. Kindly see that 18th October letter at page 218.
Cancel the tender.
Cancelling the tender, and the reason for cancellation is on the next page.
No, that the contractor are very poor, unsatisfactory.
Very poor, unsatisfactory, and you are requested to go for fresh tender.
Right.
That was the decision taken. It is on this ground that the tender has been cancelled. Now, my lord, on the very same ground, previously, they had cancelled the tender. And the judgment of your lordships is at annexure 11. Annexure 11, your lordship sees page, it begins at page 222. Your lordship takes page 224. Paragraph 3, second line. The provisions contained in clause 108B and D of the DTC and a bidder can be disqualified for past record of poor performance and inordinate delay in completion of the work, even though it's qualified and the criteria similarly as per clause so and so.
That is a submission.
That was, yes, I'll show the finding, Malad. The finding is at page 233. Paragraph 17. In view of the aforesaid facts and circumstances, since the action of the authority is arbitrary, unreasonable, and violates Article 14 of the Constitution, this court hereby quashes the proceeding of the tender committee meeting held on so and so of the counter, by which the petitioner has been declared disqualified.
Yes. Where is that clause?
That clause, Manoj, that page.
Two clauses are there.
Yes, Manoj. I'll just show to your lordship the two clauses. Page 90. No, your lordship may firstly see both the clauses. At page 68, your lordship sees
3.4 minutes.
3.4. The bidders are subject to be disqualified if they have, P is relevant, record of poor performance such as 3.4B. record of poor performance such as abandoning the work, not properly completing the contract, inordinate delay in completion, litigation history or financial failures, etc. None of this is there. There's no record of any of this as against me. The next relevant clause is at page 95, 108. Even qualified criteria are met, the bidders can be disqualified for the following reasons if inquired by the department. A, so and so. B is relevant, past record of poor performance. And I've categorically stated there is no past record of poor performance as far as the petitioner is concerned. On the contrary, Annexure 1 and Annexure 2 will reveal that I have taken up several works, successfully completed them, and Annexure 2 are a record of the works which are presently continuing to the satisfaction of the department. I have
Any certificate?
Yes, my lords. Annexure 1, I have given the completion certificates. Work your lordship may take from the
This is a government document or your document?
government document. So, your lordship may start from page 23 onwards. It goes right up to
Page 40.
page 40. Several certificates issued by different authorities, municipalities, executive engineer of the NH, several, and National Highway Authority.
But they have simply cancelled the tender and we are waiting for a fresh tender.
No, they have cancelled the tender on the premises that
Your performance is bad.
and that on the face of it is a decision which cannot be
What we
sustained.
say, what are the materials?
Millard, this morning I have received the instruction, Millard. In 13 instances are there.
So what about those annexures? What?
Millard, I have to take instruction for that and sort for that.
You had that petition with you. When they gave you instruction, did you not pass on the?
Millard, I will file a counter affidavit because it may see the instruction I have received today, Millard. On 13 instances, there are 13 instances where the performance is poor and they have not completed the work.
So have you initiated any proceeding? Have you written a letter to the?
Not even a communication to that effect. Not even a communication.
That effect, Millard, I will take further instruction because I want to see you in this approach.
The record, what is the requirement of the contract is record of poor performance. Now, that record has to be preceded by an opportunity of hearing, a communication to me that your performance is poor.
Not as a 1 and 2. When on Annex 1 and 2 that document they have attached, I will come back to your lordship. Specifically.
And my lords, had it been poor performance, I would not have been technically qualified in the first place. They would have disqualified me on the technical ground.
Have you applied your money? There is a vast distinction between unsatisfactory work and the poor performance. Satisfaction is more subjective.
And abandonment also.
There is no case of abandonment. You have simply got certain cases where they have taken a longer time than what is provided to complete the process. 6 years, 3 years, 4 years, beyond the time stipulated. Why you have allowed him to work? You might have given an extension. There may be several circumstances which may.
That is recorded for an Annexure 1, they have recorded. Land was in dispute. Site was not handed over. It is recorded under various documents of Annexure 1. Land dispute approach road, page 26.
Have you noted it in the?
Till now, they are not.
Till not. Till not.
And yeah, so your lordship, the CI file affidavit will not proceed.
The letter, the
Difficulties getting here.
So,
May I just, one more sentence, may I add? I had once mentioned to your lordship that old matters, your lordship had said that Wednesday would be dedicated for that post the puja vacation. But your lordship may kindly consider that.
From the next week, Wednesday for the old. For hearing matter. Hearing.
After notice matters may be
Not
taken.
telling. So from that week. Hearing matter from Wednesday.
HON'BLE.
24.
May I take your lordships to page 509, your lordships? Your lordships, the third time that the tender has been floated for the same work. Page 509.
Only you participate.
Your lordship, the first time there were two people. I was qualified, the other person wasn't, as because it was single tender. So they obviously had to drop. Second time, your lordships, same tender, same condition, my bid was the same. And they disqualified everybody. And we went and inquired. They said, no, we'll come up another tender, we want more. So we did not come to BICO. The third time, your lordships, same tender, same conditions, same documents. And this time they have come up with a reason which is not born from the tender documents. That's why your lordships, may I take your lordships to page 509 of the present tender which is under challenge.
Yes.
We are concerned with serial number 10. Construction of road from Bakuli to Udya Padar via Patrapur, Khalguda Road under CUVA district Malkangir the year. Now your lordships will see they are basically citing clause 2.1, which is at page 519. 2.15, your lordships. The intending tenderer should have executed similar nature of work worth 75% of the estimated cost put to tender during any 3 financial year taken together of the last preceding 5 years. In case the contract spanning for more than 1 financial year, the breakup of the execution of work in each financial year. Your lordships, 2.15. That's the bottom, your lordship, last second. We are more concerned with the first portion of 5.
12% of the estimate.
Yes, your lordship. I have to show a similar nature of 75%.
Using 3 financial years.
Yes. Your lordships, the reason is something else. They cite that clause. And your lordship find the
Was it
reason.
there in the earlier tender?
Yes, sir. Same tender, same condition. And your lordships will find the reason at 777, page number 777.
Yes. You are.
Santosh Kumar Rao, serial number 3.
Yes.
Due to not eligible in the requirement of experience and similar nature of work, now they come up with bridge part as per clause of DTCN 2.15, your lordships. So your lordships, first of all, there was no bifurcation of a bridge work and a road work. But even if they say bridge work, I have at numerous bridge work which I have narrated at paragraph 7, your lordships. There also I qualify. If you are only considering bridge. But your lordships will see from
But
the
it
clause.
does not talk about the bridge.
Exactly, your lordships.
And in the earlier tender, when you were not disqualified on this ground, if the conditions are one and the same.
You have also annexed them, I can show them, your lordships.
Which page?
Your lordships, that your lordships will find. Your lordships will go to page 254, the first tender.
Yes.
Where I have been shown qualified. Yes, your
No, I
lordship.
didn't want this.
And
There have been, others have been disqualified on 2.1 point.
yes, your lordships.
Where is that 2.1?
Yes, your lordship. That 2.15 will be at page number. Page number 33.
Is number?
33. your lordship. Same bottom, your lordships. Here, in fact, they had a division, yet they held me qualified.
Road and the bridge works.
And there they had me qualified, Your Lordship, on both the aspects. Today they have removed that.
So this was more stringent at that.
Yes,
percentage,
and I'm-
because in both 75%.
As qualifying according to them. And I've narrated the entire work.
Separately, the for road and bridge work
Yes.
separately.
Yes, Your Lordship.
Yes, sir.
Let's kindly turn to annexure page Miller, page 777.
Yes.
Towards the bottom, that I draw your attention. Last paragraph.
Yes.
The public C may submit her grievance to this office if any within 5 working days. From the
Where?
towards the bottom Miller.
You go to the bottom.
Yes.
Copy. Where?
Page,
Huh.
that's
Oh.
holding annexure.
That is just after the block.
Well, after the plus. From the date of publication of this result of technical bids part 1 on e-procurement system to have the further final decision to be taken by the tender grievance redressal committee headed by
Why you
the.
have not approved? Where?
Following page, Your Lordship,
Ma'am,
778.
Ma'am, I'm coming to that. Miller.
Yes.
The next annexure, Miller, annexure 11, within the stipulated time period, he submitted for grievance.
Correct.
Now, Miller, this repetition is filed merely on basing upon apprehension that grievance is not considered and we may proceed for opening the financial bid. Today, I have got the instruction, Miller, financial bid is not opened and that is under consideration.
But Your Lordships, they were
How
supposed
long
to.
will you continue to take a decision? Oh no, this was submitted at least a month, more than a month before. More than a month before. So
And I would not know when the financial bid would open. They would not inform me.
no, it is not going to be informed. You will record that. Where is the difficulty?
It's
And
not
they are
open.
taking and they are considering your demands. And I
Paragraph
have not
3, 4
taken
and
any
5.
final decision as of now.
Paragraph 3, 4 and 5.
here and now,
Your Lordship, then look at para T of the same document.
nothing, we are going to dispose of.
Yes,
We are saying that the grievance committee, we take a decision. What we propose is that the communication has to be made immediately after the decision. If it is favorable, no doubt. If it is not, then the financial bid shall not be open, at least 15 days time be given so that you can challenge that particular decision of the
Yeah.
committee.
right,
They will fix the date after,
right.
which will also be communicated.
Yes, I got it. That will satisfy him.
Yes. Whether that will. The
25.
Please to refund the seized amount of 12 lakhs.
That will be after transferring of that case from central circle
How
to
much time you, the last officer who asked for a time?
2 weeks. Today, probably it may be done, but I need 2 weeks that after transferring the matter to central.
Item 27.
In your lordship.
Non-constitution of the tribunal.
Yes. 28.
But the issue is the 74 B.
Yes.
Similar to the thing I guess there is a joke.
Same
method. This method is also related to 74.
Item 30.
Paid the IGST amount instead of GST amount, for which he has already sought for refund before the authority. And the authority has moved the file, she has not decided.
Lordship, please verify the matter and take instruction from the department.
This was filed in September. You must have been served with a copy of the requisition in September.
Already informed to the department, Lordship, regarding this matter. I'll be getting instruction. 2 weeks, Lordship.
Yes.
31.
This is also same as item 29, 74.
Yes.
Item 32.
This is the bottom block. So, I directed 5, 7, and 9. There are repeated communications whereas directing the petitioner to pay interest. Under section 7(5) Orissa Interest Act. What has happened in this case, you also kindly see. I take my lord's attention to page 52, annexure 5. Page 52 minutes. Take notice that by virtue of order of the Supreme Court, is civil appeal number so and so, State of Kerala versus William Fernandez and batch of civil appeals, they were demanded payment of 50% entry tax amounting to 1 crore 2 lakhs 41 so and so withheld on scheduled goods imported from outside the country into local area of the self-consumption or use of self covering the tax period mentioned above. Period mentioned is 1/4/8 to 36. Because now they say that you have failed to deposit interest amounting to 2 crore 46 lakhs. What is the interest component? 2 crore 46 lakhs. Last paragraph. Interest component. Interest component. Not the tax. Not tax. Tax is entirely paid, Milos. There is no controversy. They also say. They also say, Milos. Last paragraph, you are here.
Perhaps restrictions, that's okay. Restrictions, we have imposed 9%.
No, that is different. That you are decided to see Bharat potential.
9% or 12%?
That is altogether your lordship directed for the purpose of that on the basis of equity saying that in case of trust.
You will stay.
Supreme Court.
This code directed for 9%.
9% your lordship have said to balance the interest of the parties together. So the state has not got the money for the time being.
You paid 50% at that relevant point. of time.
Yes.
For the rest, 50%, though you have deposited, after larger than decided,
Correct.
9% this court has said, instead of statutory interest 12%. This interest component comes on 12% or 9%.
Your lordship in the Sri Bharat judgment said two things. One is, so far as statutory interest under section 7.5 is concerned, your lordship struck it down saying it's not available. Don't can remember. One. Second, so far as there's interest not covering 7.5, that is the case related to para 30 goods, Reliance Industries case, which are covered relating to Sri Bharat Motors and several other spheres. Your lordship said, because the money has been held off and it was paid belatedly, so until the date of the judgment, from the date of amount becoming due, till the judgment released by the Supreme Court. But there are two things. One is till judgment Supreme Court, and from the judgment of Supreme Court till the date of actual payment. Like this. So from the date of amount becoming due till the date of judgment, your lordship said, now that even though stay was operating, but because to balance the interest of the parties, your lordship directed you pay 9%. And that matter is now pending with Supreme Court. On the Supreme Court issued notice and directed not to recover the amount. Those are there in several forms, several entries. And I have also arranged all those entries what was there. Sorry? Those yes. Those are different because those are the cases in respect of 9% below. Those are covered, your lordship, para 30 goods, covered Reliance Industries. Those are approved. But I am not there. I am only on the point that these three communications under Annexure 5, 7, and 9 by the department are purportedly demanding interest under Section 7(5) of the Orissa Anti-Tax Act, which your lordship has specifically said in Sri Bharat that they are not collectible because of the ingredients pillar 7(5) postulate some contingencies. Unless those contingencies are satisfied, 7(5) interest cannot be levied. Because that is the only enabling provision available on the Orissa Anti-Tax Act to demand interest. There is no other provision. So far as these communications are concerned, your lordship is concerned here in these three communications.
Conditions.
Yes.
First thing is that if you fails to file the return or pay the amount of tax due as per the return or any tax period.
Without sufficient caution.
Whatever.
Yes, that is important.
Or fails to furnish the return.
Yes.
They may be liable to pay interest in respect of a tax which they pay to according to the return or fail to furnish the return. 12% per annum it will come and it will be more actually 1% down per month.
Correct.
Now question is that if you fail without the sufficient cause.
Correct.
Now the question is that whether you were prevented by a sufficient cause.
Absolutely.
Or there was a sufficient cause in not filing the return.
I am not coming out of that. I have filed the return. So now second question is whether there is sufficient cause. First, let us eliminate the first one. There is no question of non-filing of return. Second is non-payment of tax due as per return. Now, supposing I admit 10 rupees, pay 5 rupees, and I do not pay the balance 5, then that will come out to 7.5 unless I establish before also belongs.
No, filing of return is sine qua non
Minus.
for invocation of 7.5.
Correct, Minos.
Second thing is that if you have not deposited the full amount of tax.
Correct.
As you have indicated in the return.
Due as per return, yes, yes. Correct.
Indicated in the return.
Correct.
Then unless you give a sufficient cause.
Fine.
That this prevented me not to.
Correct.
Then otherwise you will be attracted with the interest.
Correct. Now,
what is your problem?
Now let us see the communications. The communications which are not a challenge for Lordship Minos. Kindly see the communications which are not a challenge for Lordship Minos.
Yes.
That's page 52, last paragraph, Minos.
Yes, that is open. You are hereby running and impressed upon.
Impressed upon deposit outstanding interest amount to 2 crore 46 on 7.5. Telling which action will taken. Then 55, page 55. I responded, saying that I have paid 50% and balance also I have paid. That's then 55 page. You are once again honestly requested a impressed upon to deposit outstanding interest of 2 crore 46 on 7.5. 7.5. Positively, we are hard.
2 crores. 2 lakhs. 2 crores.
2 crores. Yes, yes. 2 crores 46 lakhs 47,000. Then what I said, you also kindly page next page 56. My response was the last paragraph of my response. In this regard, we respectfully request that you may kindly provide a detailed calculation of the interest amount, including the rate of interest applied and the basis of computation. This information is essential for us to engage our corporate legal team and fully understand the demand considered in the Supreme Court's order. Then 57 page Minos. Now, after getting this, what they said, I am to enclose a copy of the detailed calculation sheet in both hard and soft copy on interest calculated based on returns filed by you from the period from 1/4 to 36/17. Interest calculation based purely on your self-assessed return figures. What then? Next page.
Correct. Yes.
Now, next page, page 58 Minos. What they have given by also kindly see Minos. Period. Whereas 8 may be read as 2008-9, OET payable, entity tax payable. This is the payable figure, Minos. Then 50% OET paid, Minos. Next column, balance 50% OET payable. Then due date, it has no meaning, Minos. I don't make out anything. I probably, your lordship also cannot make any sense of it. Due date means they said the 305.93. This doesn't make no date is there. Then next column, my lords may kindly see, number of days delayed up to 28/3/2017. I don't know how this date is sacrosanct because all this matter your lordship is concerned with us. These are concerning import bills. The judgment of the Supreme Court in this case, as a status judgment in case of William Fernandez, came on 9/10/2017. So, if the assessing officer would have in mind the date of judgment, the date of judgment relevant for this case is 9/10/7, not 28/3. 28/3 concerns the Jindal Reliance case and Haryana Jindal's case belongs. That is 28/3. We are not concerned because your lordship is concerned only import belongs. And the judgment is 9/10/2017 belongs. So this date is also wrong belongs. Next belongs. Then interest payable till 28/3/2000. Again, this is wrong because this range has no relevance belongs. Date has no relevance. Date of payment, nothing is mentioned. They say 000, whereas date of payment not mentioned. And number of days delayed, 0, no delay. Number of days delayed from 28/3/17 to the date of payment, 0, no delay. Then interest at the rate of 2% per annum, 0. Then number of days delayed up to 31/5/21 from 28/3/2017. Again, this date has no relevance at all. Because date of payment is not there. Here they say 28/3/17 and they have calculated delay. Then interest payable from 28/3/17 to 6/12/2021. Because these are not relevant, I don't understand because one thing we lost, all these things your lordship will find that prima facie error in the statement is there. Nobody can make out how the computation has taken place. it must be clear, accurate, and the assessee must have access to the basics of computation, which is pure lacking in this case. And the date has no relevance. Delay is zero. And all these things have to what I meant to submit first. There is also no order because 7.5 it must be a rigid order.
So by now has understood.
Must have understood.
I can understand if my learning senior
Let you work out.
educate the
Let you
grievance.
work out the actual
If my
liability.
learning senior educate the grievance that there is any dispute in calculation. So your lordship,
Ask for the calculation.
your lordship.
You have failed to you take correct figures.
I will, your lordship. I understand only whether he is liable to pay or not, it is to be decided. So if there is any calculation error, I am ready to provide him calculation, the right calculation. Your lordship, because
the precision he wants accurate
Your
days
lordship,
of delay from which date to which date, how you calculate.
your lordship, because here there is no lease pendency, your lordship. Your lordship may kindly looked into. Your lordship may kindly looked into these three orders. One order in 2012, where he has challenged, the petitioner has challenged the constitutional validity of entity.
We are not going.
Your lordship, let me. Your lordship, after that, Honorable
Yeah, I
Supreme Court.
can argue for hours. That is not an issue here.
You answer 8. That's all.
Your lordship, Annexure 8, your lordship, I will take instruction and I will provide the detailed copy. Detailed copy, your lordship. That is not dispute. He is liable for make payment of the entry
Let
tax
him go and let him pass
because
first one.
he has already withdrawn his writ petition here with the liberty to file appeal. So far as the calculation, it is self-calculation.
Please confine yourself particular thing that answer 8. Reply.
Yes, Annexure 8, I have not gone through, your lordship. So far as the Annexure 8, I admit, concede myself, I have not gone through the detail of calculation. I will take the instructions so far as the calculation is concerned. I am concerned, your lordship, I am concerned that the levy, the payable of the interest, even after, my lord, even after Supreme Court judgment, more than 1 crore is holding. And both your lordship, more than 2 crores, he is holding the entity tax interest, which is payable since 2012. Your lordship, government revenue, your lordship. And on a plea that 7.5 is not applicable. This Honorable High Court's order has never stayed by Honorable Supreme Court in 2012. So even Sri Bharat judgment.
Misra.
My lord, I admit, my lord, I am conscious so far as your lordship because admitted revenue.
From 2009.
Yes, your lordship has argued that matter. Your lordship has argued that type of original matter.
That's why I know where the shoe pinches.
Your lordship.
Please confine your
lordship. Your lordship on next week, your lordship, so far as that instruction, so far as the Annexure 8 is concerned, your lordship.
It should be.
Your lordship, what my respectful submission, there is no lease pendency. Even under 304A, which has been remanded by Honorable Supreme Court in William Bernardes's case, he has withdrawn.
This
Your lordship, that in the last juncture, in the last page, the calculation is 1,45,97,545 is the interest. The intervening period from 2012 from the date of payable till 2017.
the manner application you have blockade. Isn't it so?
My lord always say, reading the live link between the decision taker and the decision taken. Your lordship always says so. Your lordship, taking into account Steel Authority of India case, Punjab, your lordship, the Bhag Singh versus State of Punjab. Your lordship always, your lordship, the live link inscrutable speaks, your lordship always tells so. Your lordship. So therefore, some reason is to be given, whether it's a fit case where 7.5 engaged is satisfied, and the department before claiming interest must have to ensure that there is attraction of these two contingencies. It has been attracted and is liable. When this allowed specific and 7.5 statutory interest that is no more liable because of the antecedents where at the different stages, Honorable High Court, Orissa High Court, Supreme Court has also granted stay. I also annexed the order by virtue of interim orders passed from time to time by this court and Honorable Supreme Court because money has been paid. So that constitutes sufficient because my lord has devoted 4-5 pages in judgment I have come across lords on section 7.5 and this constitutes sufficient cause lord. The only question remains 7.5 your lordship from it out. They know.
Recently, your lordship was passed out.
Brother,
You wanted now invest 10 pages on 7.5.
Recently, your lordship has passed.
At least the officers should devote. Officers should devote a few lines to justify how 7.5 interest would have been attractive.
You should have it. That's too time.
Maharaj, I can understand that since 1999.
You have not understood the thing.
Since 1999, revenue is fighting against this 80 tax matters, your lordship. From 9 judge bench, from this High Court till 9 judge bench, and everywhere we own the case. Department has owned the case, but nothing could gain, your lordship. Your lordship, that 50%, 2/3, your lordship, has been held up since 2008, your lordship. And 2025, we could collect those amount, your lordship, after many fight, your lordship. Your lordship, all the judgment, 1,000 pages of judgment, 9 judge bench has passed. And your lordship, this court has passed many judgments, your lordship. And even after that, my law engineer says that no interest is payable. Your lordship, your lordship.
1800.
Your lordship, I don't, it is, your lordship, more no.
That dicta for enforcement still holds good.
Your lordship.
Which is not there in the statute.
And even your lordship, even Honorable Supreme Court has not stayed that 2012 order. In Reliance Industry, your lordship might have remembered, 2008 order has been stayed by Honorable Supreme Court. Your lordship subsequently modified in 2010, your lordship, 3 February 2010, to pay 1/3. And this Reliance Industry, this Tata Steel case, batch case, has never been stayed by Honorable Supreme Court. Your lordship, your lordship, your lordship,
Mr. Item 33.
The next 13 is the certified from the
Very interesting way of lighting the petition. The relief sought for, you always say the prayer. No, it's good. Innovative. Yes.
What's the lordship says here, the dispute is regarding the engagement of Anganwadi workers. The present appellant.
Suppose are filing an appeal in the form of an application supported by an affidavit.
This is not supported. This particular appeal has not been supported by it's.
No, the prayer, release, what is this? Certificate? Sorry, the relief, how can it be, how can there be amendments made in the claim? How there can be an annexures to the memorandum? You're not supposed to annex any like a petition. The memorandum will be there, only it will contain the impugned judgment and the Mokalatnama. Not beyond that. I'm really watching, I've been watching that there are a petition like this. The writ appeals are in the form of a petition. So where you got this? And now I'm going to go to my brother who has taught me this Orissa High Court rules. It talks about the memorandum, it does not talk about the application. memorandum in terms of order 41 rule 1 of the Code of Civil Procedure. There what it should contain is already provided. That these are the documents which the memorandum should contain.
Filing like this. So, Mr. And Mr.
What is this? I'm really surprised the memorandum with the annexure. Who will certify?
We all filed in that form. Not in memorandum. Not in memorandum. We filed this form.
Mr. Mishra, both the senior Mishra. What kind of a procedure is adopted here?
So your worship is correct, actually. The memorandum has been defined that order 41 rule.
Rule 1. And it says that the form of the memorandum, what should it be? How it has to be made?
GRC also provides that.
So,
No,
this is annexure, every ground with the annexure. What guideline is annexed here to, then this letter is annexed here to, advertisement is memo. It will only contain the grounds on which you wanted to assail the order.
It's an appeal.
It's true.
Appeal based on the documents filed in the before the honorable.
No, memorandum will not. It will only contain the grounds.
No.
That's all. Application for stay or whatever you have to file in the, but the registration will be done on the basis of the memorandum.
Yeah. That is the.
I do not know.
No, your worship is correct. They should amend themselves, correct it.
And memorandum containing the relief sought for, like a petition. Certification, I can understand, you will certify that in my considered opinion, the grounds taken in the memorandum of appeal are good ground for an appeal. I can understand to that certificate you can give. That is also not required in case of a mandamus appeal.
He's quite experienced enough, he'll do it, sir.
No, I'm just generalizing the dimensions that now this is prevalent, sir. If I take us, this is now, and then tell the registry not to accept, then you people will come.
Normally.
Then many of the members are facing problem with this. Don't take it. That's why I invited your attention.
No, your worship is correct.
So registry also pointing out that effect, that certificate is not there, affidavit is not there.
In the first regular appeal, there is no certificate which is required. It is the last court of fact and law. When I say it's the last court of fact and law, means that the first appellate court will decide both the facts as well as the law. But once it goes to the second appeal, then substantial question of law, which is distinct from the question of law. Every question of law may not be substantial. So there the certificate is to be appended that in my considered opinion, these are the good ground for admission of an appeal or involves a substantial question. First appeal it does not require.
First appeal is fact and law.
Yes, writ at large, both fact and the law will be decided by it. I do not know.
Sir, actually previously, if I rightly remember 30-40 years back, only the 2 pages second appeal was being filed, only the grounds.
Only grounds. No,
now,
fact was
now
also
it will
stated.
be,
Second appeal, no facts were
amended, but they say
we are not used to writing the facts also.
No, not necessarily.
Only grounds, substantial questions are
Look at order 41 rule 1, it does not
being
provide
agreed by
any
such and such.
narration of the facts. Does not provide. It is only the grounds.
And nowadays, I also saw that the second appeal also, they're stating the fact, they're not getting the question of law. So that is also.
Sir, in case of review also, sir, if you look at order 47, it says that the review must be filed in the memorandum form.
Yes.
And then it talks about an application for review. So generally what is adopted is the memorandum is filed and an application for review is also filed along with that. the application will contain all the facts and the grounds. But the memorandum has to be filed. Right. But the review, I find no memorandum is filed. Application for review. Look at it, it talks about this is done. Nobody takes care of this.
Really, on the bar. I was also there. Normally, writ appeals, we draft like repetition.
And some additional documents are also filed along with here.
Yes.
That is not, that should not be acceptable.
Yes, chapter 8. Chapter 8. Chapter 8, rule 2. Rule 1 also. Rule 1. Chapter 8, this that speaks about memorandum.
Look at order 47 rule 3. The review part. Review part. I'm just talking about this.
The provision as to form of preferring appeals shall be noted in that line.
So that's the memorandum. Correct. That is the whole difficulty, sir. The system has to be, what you say was really definitely that should be restored. Which was the tradition and the everything was followed in this code. Memorandum containing only the grounds. And no annexures.
This rule 2, chapter 8.
Yes, I've seen that here.
38 for orders it is latest.
I have given a document.
In this case, madam, I have applied for the certain document under RTA matter. I have received and prepared affidavit to that effect. I'm filing today, madam.
You are disposing of the matter and you are filing it too.
For orders only. Yesterday.
We have heard everything and we kept it for order.
That's what I was doing. PIL matter.
Yes.
Government matter that doesn't.
Yes, I have heard.
During pendency of the writ application, I have applied for the certain document under RTA. I have received. I am filing it and your lordship please.
You can pending it further, but we do not want the.
The three judgments have been given.
One elaborate order is discussed.
Yes.
The other one following this.
Yes. There are three judgments in first.
No, everything has been taken note. No difficulty.
Okay, so 2030, as I received my, after 2030, that account has not been.
Sir, it was kept for judgment. Will you come and say that this is what? It has come for judgment. We heard you many a times. Everything was heard, concluded. I think it's judgment has been prepared to that.
Let item 40.
provides for, my lord.
My lord, I'm at the opposite person.
Supreme Court.
Because I have got submission on that.
How can you,
My
half
lord,
of the value?
no, half of the, I will make little bit submission on that. My lord, lordship will take it up tomorrow.
Tomorrow, little bit submission.
Tomorrow, deeply obliged, deeply obliged.
Kindly be taken up tomorrow, my lord. Orders